here because ADR is very close to my heart. As a judge of the Lahore High Court, as the Chief Justice of the Lahore High Court, I made every possible effort to ensure that the system was not only introduced, but it was also successful. And in the process, one came across a lot of hurdles, legal, procedural, bureaucratic. We had a lot of partnerships. We had CLDP, we had the American embassy, their advisors, they tried to help us out. And we had a certain degree of success. But as has been pointed out by Justice Amir Farooq and Justice Sardar, that these matters need continued support. They need continued effort. They need continued ownership. And most of all, ADR needs a particular ecosystem. You have to have systems in place where there is ownership of the judiciary, ownership of the executive, ownership of the litigant, who is the main client, so to say, of whether you call it the judiciary or whether you go to the ADR center. The main factor or the main recipient or the main beneficiary is and should be the person who wants to get this matter resolved, in which he is voluntarily or involuntarily involved. But for that, there has to be a system in place, there has to be awareness, there has to be ownership, and there has to be confidence in the system. And it doesn't come overnight. It takes a while, it takes a lot of work, it needs a lot of spade work, it needs a lot of effort, and it needs a lot of training. It's not easy to be mediator or act as a mediator or mediate between the parties who have been locked into litigation for years on end. So to show them another door, to show them another option, to put them across the table and try to come up with a solution which satisfies both parties and ends up in a win-win situation is not easy. You need specialized training for that. I'll get down to that in a little while. But first of all, I would, on a lighter note, like to correct Shazir. It's not a committee, it's a task force. So somebody asked me, why do you call it a task force? I said it has more gravitas, you know, when you hear about a task and a force behind it. It is accepted more seriously. And we have, over the past year and a half, done very serious work. We have, you see, because at the Supreme Court, you had to have a system, you had to have a policy which would be countrywide. So there are high courts, Lahore High Court, there is Sindh High Court, there is Balochistan High Court, there is Islamabad High Court, there is Peshawar High Court, and all of them are making efforts to introduce this system, because all of us, I would stop for the azan. courts, and at the Supreme Court we realized that all high courts realized the utility and the importance of ADR, and all were making efforts in their own various spheres, individual spheres, to make progress. We wanted to bring all high courts and all efforts at the same level so that we could we should go forward in tandem, and we could utilize the experiences learned by various high courts in their efforts, and bring all high courts at the same level, so that the process of litigation, the process of legislation, the process of rule making, the process of training, the process of accreditation, that could be sort of centralized, and it could be granted uniformity. And we have had considerable success in that. We have had discussions, we have come up with certain conclusions, we have involved all stakeholders. Now, in the task force, we have representation from every high court. We have representation from the law ministry, the provincial law ministries, the federal law ministries, the finance department, where there is involvement of the finance department, and we are making quite a lot of headway. And I'm very delighted that this project has been started with Islamabad High Court, for the reason that all along I was a firm believer that Islamabad is one area which has all the ingredients but in one place, and a very manageable sort of system where you can introduce this, you can check out whatever systems you have put in place, you can address the teething problems, and once you have come up with a system that works, then we can replicate it on a larger scale in provinces like Punjab, which has 37 districts, each district almost the size of Islamabad. So that would give more confidence to the planners and the lawmakers and the litigants that yes, here is a system that has worked, and it's working, and we have seen it work in Islamabad. We have seen the problems, we have fixed the problems, and now we can move forward. Likewise, we have looked at the grassroots level. Our first and foremost client, as I mentioned earlier, and as Justice Ijaz's Haq also pointed out, is the litigant. So awareness of the litigant is of prime importance. And in the age of media, the electronic media, the print media, the social media, it is easier to reach out to people and tell them that there are alternates available, and they need not go to courts in the first instance. There are a large number of cases, there is a large number of issues which can be resolved even without going to courts through third-party mediation. Likewise, there is an option that, and I want to talk about that we cannot or should not limit ourselves to only to cases which are pending in the courts. I mean, people should know that we need not go to the courts. We can directly go to the mediation center. A mediator can be appointed. He can talk to the parties and maybe come up with something which is acceptable to both. And subsequently, an enforcement mechanism can be put in place where, I mean, you can move an application in court and get the mediating or mediated settlement incorporated into an order of the court, and ideally a decree of the court. But for that, obviously, one would require litigation, legislation, and that's a longish process. But what I wanted to say is there are various stages that we would have to cover, and the stages start from awareness, the stages start from putting in place the systems. And I think I would congratulate Justice Khilji Arif Hussain, who has identified Islamabad, and I must say, rightly so, to at least put in place the system and see how it works. And as much as I have heard, they have had considerable success in Karachi, and they have managed to get good results from cases which were referred for mediation by the Sindh High Court and by the district judiciary. So the task force as well as the Supreme Court is fully supportive of this action. But what I want to emphasize is that there has to be continuity and there has to be ownership. The high courts not only should ensure that there is continuity of the efforts that are being put in this initiative, but there has to be ownership of the high courts to ensure that this process continues, because in the ultimate analysis, it is the judiciary that also benefits in terms of reduced dockets and reduced number of cases and more time available to the judges to those cases where there are complicated legal, procedural, constitutional issues involved, and pay their more attention towards those issues which cannot, despite effort, be or are unsuitable to be referred to mediation. Justice Gul Hasan Aurangzeb pointed out the example of Turkey, and I think Turkey should be the poster boy for this initiative. I mean, 3 million cases is a lot of cases. And imagine if those cases had ended up in courts, what would have happened to the dockets? So we have likewise recently visited Malaysia and seen how their system works. I had the opportunity of visiting Indonesia, and there we saw the system work. And it is not only working, but also working very successfully. So I was very pleased to see the mediation center that has been set up, courtesy Chief Justice Amar Farooq and courtesy the judges of the High Court. And I mean, it is. I saw a lot of similarity with the ADR centers that we saw in other countries. It is the state of the art. It has a very conducive atmosphere, and I feel that this would be something of a model to follow, and we'll see, hopefully see, good results coming out of it. Another point that I need to focus on is referral. I mean, as long as the systems are working in tandem and awareness is increasing, there are cases available and running in courts which are ripe for and which are suitable for mediation. And I would encourage the district judiciary and as well as honorable judges of the High Court to look at cases from that point of view also. Every day when cases come before them and they see the list, they would be or should be able to identify which cases are suitable for mediation and encourage the parties to take that route, take that option, emphasize to them the advantages of getting their disputes resolved through amicable mediation, and which would save them cost, which would save them time, which would save them the agony of prolonged litigation, which can take generations, which I'm sure nobody wants. So the role of the judiciary in encouraging and referring the matters to these mediation centers uh, is absolutely vital, and I would encourage the judges to do that. Another point that I need to make is we need also to focus on training of mediators. I mean, 36 or 60 mediators have been trained. That's good progress, but it's seen on a larger scale. I mean, if we are looking at rolling out a mediation system in the entire country, we would virtually need hundreds of trained mediators. And for that purpose, we are also making an effort. We have talked to universities, we have talked to academia, we have talked to law schools, and we have told them that we would encourage them to introduce at least optional courses where law students can opt for courses where they get mediation training. And once they pass out, in addition to being lawyers, they also are trained mediators, and that is an option that they can follow. I can tell you there is a lot of appetite for that. A lot of law schools are talking to us, a lot of universities are talking to us, and we are looking at how the curricula can be framed, and what needs to be taught, and who needs to teach those subjects and those optional courses. Likewise, we have brought in the judicial academies, which are in all four provinces, and encouraged them to start mediation courses not only for judges but also for lawyers, where they can bring in trained mediators to impart training not only on judges and on lawyers, but also to train trainers. And we were just talking about a project which is being run with international collaboration, where trainers would be trained, and I think that would go a long way in our dream of having hundreds of trained mediators who are available and who can perform this service. Now, finally, I think, agree with Justice Kiani when he was pointing out that the cost of litigation law needs to be brought in and utilized in order to emphasize on the parties that frivolous, ego-driven litigation can cost dearly. And if they have genuine cases and they have relatively simple cases, they have an easier route through mediation, where they can get their genuine issues resolved in a fair, amicable, and transparent manner, and in a manner in which both parties end up in a win-win situation. And that is entirely doable, and I think a little push by way of imposing costs, and heavy costs where there is absolutely frivolous litigation, can be a good tool. So all in all, I think we are on our way. This is a good start. The high courts are cooperating. I am very happy to note that the Islamabad High Court has taken the lead in this, but at the same time, we have very high expectations of the judges of the Islamabad High Court and the Islamabad judiciary, that they would refer maximum number of cases to this ADR center, where they have all the paraphernalia, and they have the manpower, and they have the expertise to deliver and to deal with whatever number of cases is referred to them. So we would be looking closely at what happens, and with a prayer in our heart that this succeeds, so that the success of this center would encourage other high courts to replicate the systems and introduce ADR as a system, as a recognized system in which not only the judiciary but the litigant also has confidence. In my opinion, which is shared by many, ADR is without a doubt an ideal option that the judicial system must strive to adapt. Before I conclude, I would like to, on a lighter note, show why one should prefer mediation as opposed to litigation. Fans of Charles Dickens and lawyers alike will no doubt be aware of one of his finest books, Bleak House. The central theme of the book revolves around the Jarndyce family and perpetual litigation that embroils that family for generations to come. Dickens writes, and I will quote a passage from his book, "Jarndyce and Jarndyce drones on. This scarecrow of a suit in course of time became so complicated that no man alive knows what it means. The parties to it understand it the least. Scores of persons have deliriously found themselves made parties in Jarndyce versus Jarndyce without knowing how or why whole families have inherited legendary hatred towards the suit. But Jarndyce and Jarndyce still drags its dreary length before the court, perennially hopeless." While Dickens wrote these words in 1850, the message is clear. To ensure justice, mediation must always be an option. Jarndyce and Jarndyce may be fiction, but with mediation, I am confident we can endeavor to ensure that it remains a fiction for times to come. Thank you very much, and I wish you the very best.